Hey guys, and welcome back to today's video. In this episode, we've got quite a few things to cover, including a brand new sovereign citizen case that's definitely going to make you shake your head, as well as an update on a previous sovereign citizen I talked about in an earlier video. But before we dive into those two crayon eaters and their latest antics, we need to start with a completely different situation involving a male Karen who apparently had a little too much lead paint for breakfast yesterday and ended up making an outrageous threat to hang a judge right outside her own courtroom. It's one of those stories that sounds so ridiculous you almost can't believe it actually happened. But unfortunately it did, and the details are just as wild as you'd expect. So, we're going to kick things off with that incident first, break down exactly what went down and why it escalated the way it did, and then after that, we'll move on to the sovereign citizen chaos and catch up on the update from the case I previously covered, because there's definitely a lot to unpack today, so let's not waste any more time and jump straight into it.
Phone number that ends in 8883. Can you please unmute your device and tell us your first and last name? It's star 6 to unmute. Hit star and 6 to unmute the device. 8883. Please hit star 6 to unmute your device. We can't call your case if we don't know who you are.
Hello?
Yes, please tell me your first and last name.
Well, my name is Benjamin Meyer, M-E-Y-E-R, unlike the paperwork that I've been sent. But it says M-Y-E-R. It is not me. I am here under duress.
Mr. Meyer?
Yes, ma'am. M-E-Y-E-R, not the person you had spelled on this paper.
Mr. Meyer, please stop talking.
Yes.
The court will call the case of the state of Michigan versus Benjamin Meyer, case number DIB 053809. Is that correct?
See what's for the people.
267659. Thank you. Mr. Meyer, you've placed your name on the record a number of times at this point. You're here for a contempt hearing today. Mr. Meyer, you owe this court $168. When do you plan to pay it?
I do not plan to pay it because I don't own it. Period. End of discussion.
Okay. Well, then what I'm going to do, Mr. Meyer, is find you in contempt of court.
And what you're going to do is find yourself in a 1984 federal lawsuit.
All right. Let's do it however you want to do it. You're found in contempt. You need to be here in person.
Absolutely not. I will not be coming to your court for any fucking reason.
You know, if she actually does decide to blow you, she's probably going to have to make the trip down to the jailhouse, because that's most likely where you'll be spending your time receiving any kind of favors over the next few years. And honestly, if you really did pay all those fines and fees like you're claiming, there are much easier and more believable ways to prove it than just saying so. Something simple like bringing in the receipts or official payment records would clear that up pretty quickly. But since that little situation is out of the way now, let's move things along and head over to Judge Bruni's courtroom, where we're dealing with a sovereign citizen who seems convinced that he doesn't have to pay child support at all, simply because he believes he never contracted with the court in the first place, which, as you can probably guess, leads to the kind of confusing and frustrating courtroom exchange that tends to happen when someone tries to argue that particular line of thinking.
Bench warrant to issue.
And what you're going to do is find a gunfight and a fight on the side of the fucking road.
All right.
This fine and fee was paid 10 years ago or more. Now, you can either fucking listen or we can do this out in front of your court.
Mr.
This
Meyer.
fine was paid 10 years ago. Will not be paid again. You fucking damn near shot me and killed me. Are you fucking kidding me? Have you goddamn lost your fucking minds?
30 days in the Washtenaw County Jail. Keep it up. We'll go with more.
And we'll see you hung in front of Washtenaw County Jail.
All right. Threats. I'm going to report that to the Attorney General.
I'm reporting you to the fucking Attorney General. Are you fucking nuts?
Okay. Everything you're saying is being recorded.
You are a goddamn tyrant.
All right.
I called the
60
goddamn
days.
fucking attorney's office and you fuckers rejected me. Are you insane?
60 days in the Washtenaw County Jail. Keep it up.
Oh, you'll find yourself in prison, bitch.
All right.
You think you're a goddamn king? You're a fucking tyrant.
90 days in the Washtenaw County Jail.
Below me, bitch.
All right.
Did you just say that you made your kids in private? So you're going to raise them in private? What does that even really mean? I mean, I certainly hope you made them in private and not out in public, but the statement still doesn't actually explain anything. And besides, the moment you decided to bring this motion into a public courtroom, that whole argument kind of falls apart on its own. On top of that, unless you somehow managed to create this child completely by yourself, which, as far as anyone knows, isn't how that works, then what you're saying doesn't really carry any clear or legitimate meaning in the context of this case. It sounds more like a phrase meant to avoid the issue rather than something that actually addresses the responsibility being discussed here, especially considering that child support and parental obligations are matters the court is specifically responsible for handling.
Mr. Smith, it's the middle of page 1.
Yes.
He does not want to deal with me because he does not have a contract with 4D, with any 4D workers, so he doesn't want really to talk to me. He wouldn't talk about the motion, so I'm going to submit a recommendation that the motion be denied.
Okay.
Okay, he's very difficult. I know that you read through all the paperwork. He is the individual that was talking about how he has continued to talk about that he's, he has all these constitutional rights, and he's I don't know. I can't even explain what it is he's trying to get to or what he's trying to talk about. So
Okay.
So there's not much I can do. He just basically told me that I'm not someone that he's willing to talk to because he doesn't have a contract with me.
He maybe doesn't want to talk with me either, but you can get Sarah. You can bring him in. And
I can get him.
That.
Yeah, and I'm in the process of sending you the recommendation that the motion is denied, but I can go and get him and bring him in.
Thank you.
Thanks.
A motion of the defendant, Father David Smith Jr., to modify custody and parenting time. This hearing is being conducted via Zoom. Present is Sherry Zorn, as well as David Smith Jr. Mr. Smith, it is now 9:00, and you are before Judge Brownick. Good morning.
Sir, I can barely hear you. I was in my vehicle where I could, and fortunately, we're back in front of Title 40 incendifications. If you can give me a second so I can make it back out to my vehicle so I can hear you, I would appreciate it.
Okay. Do you want to zoom back in then?
I'm parked right outside the door. Give me 60 seconds. I had to come back inside because whatever just went on.
Mr. Smith, your current parenting time is alternating weekends, Friday at 5 till Sunday at 7 with your 2 children. Is that correct?
Yeah, but we work outside of the order. I mean, I got numerous evidence that we do work outside of the order. That was arbitrarily done to maximize the dollar amount pursuant to Title 4D.
Well, that's wonderful that you can both be flexible about parenting time with your work schedules and the children. That's once we work together. I'm just noting that the last order of the court, August 2015. So I do review these files in advance. I review your motions. I review the past orders. I review the history of the case, Mr. Smith. I
appreciate that.
So I'm just noting that the last order gave you specific parenting time, alternate weekends, Fridays at 5 to 7 Sunday at 7. And you could have additional parenting time, but that's your absolute minimum. Now, in your motion, you're asking for an 80-20 split pursuant to your 14th Amendment to the U.S. Constitution. I don't know This is not a constitutional issue. It's a state law issue,
Sir.
Mr. Smith. And in
Sir.
order for,
I
let me
object.
first of all, have you talked with Ms. Dorn this morning? Do you have, the two of you have an agreement? Certainly if you have an agreement, you know
I
what's best for your two children.
Sir,
We do not.
am I
Okay. So is there any merit in talking, Ms. Dorn and Mr. Smith?
I object.
I'm going to go out on a limb here and say that you probably did consent to making that baby. And since there was clearly another party involved in the process, your sudden claim about a lack of consent is, at best, a little confusing. Sure, we can acknowledge that you're saying you don't consent now, and the court can certainly note that statement for the record, but that doesn't really change the situation or the responsibilities that come with it. At the end of the day, the fact remains that a child exists, another parent is involved, and the legal obligations that come with that don't simply disappear because someone decides after the fact that they don't recognize the authority of the court or claim they never agreed to it in the first place. So, while your objection might be heard and written down, it doesn't actually alter the reality of the situation or the outcome that follows from it.
The non-TANF case. Am I presumed to be innocent at this time with all my constitutional rights in full force and effect, sir?
Absolutely, you're innocent, but there's no criminal charges here, so I'm not sure what you're innocent of.
But
Mr. Smith, no one's accusing you of anything. I'm just asking, normally the two parents will talk, and maybe they come to their own agreement, but that apparently is not to be possible this morning.
This is a non-TANF case getting treated as a TANF matter. I want split custody, mutual agreement, all Title 40 incentivization cease and desist immediately. I will be sending letters out today to all parties that touch this case negatively, and I'm pursuing charges 42 U.S.C. 1983 and Article 3 corporate deprivation of rights. This is arbitrarily done underneath color law. I do not consent. I have not contracted with Title 4D. I would submit into the court's blessing versus Freestone, Wehunt versus Ledbetter, sir. I don't presume ignorance on the court behalf today, therefore I'm left to believe something much more sinister is going on here.
Right, Mr. Smith, it's not a constitution, under state law, Michigan law, there must be...
I do not acquiesce to state law, sir. I operate on federal law only. This is impeding my rights. I am going to transfer to Article 3 court and pursue. I'm going to file an emergency injunction if I can't even make my bills. Due process has been violated. Fair Creditors Act of 1970, you guys are taking well over half of my check. I can't even make my bill. This forces me into my 13th Amendment, which is enslavement. Pursuant to no lawful money, this is a bill of pain and penalty underneath Article 1, Section 16 of the Constitution, sir. I do not consent. I do not consent.
Well, I think everyone here would probably appreciate it if you went back to whatever constitutional law school you believe you graduated from and took a little more time to understand what facing your accuser actually means in a legal context, because that principle specifically applies to criminal proceedings, not civil matters. Child support hearings fall under civil law, which means the rules and protections that apply in criminal trials don't necessarily work the same way here. So, bringing up the right to confront an accuser in this situation doesn't really strengthen your argument the way you might think it does. In reality, it just shows a misunderstanding of how the legal system separates criminal cases from civil disputes, especially in matters like child support, where the focus is on financial responsibility and the well-being of the child, rather than determining criminal guilt or innocence.
Your position is duly noted for the record, Mr. Smith. Mr. Smith,
Thank you.
under Michigan law, which this court is bound to follow, there must be a change of circumstances that would support a modification of custody and parenting time. In your motion, you've not alleged any change of circumstances that would warrant a review of custody and parenting time. So with all due respect, the court at this time will deny your motion to change custody and or parenting time.
I have the right to my privacy. I can't even make my bills with what you guys have done here today. I can't, honestly, I have proof. I would like to submit into the court's Exhibit A if there is no objection. I have a pay stub right here. I work 58 hours a week at $30 an hour. I come home with less than $300. I can't even make my bills.
That's an issue of child support, Mr. Smith. You're asking to modify custody to parenting time today.
I am
If you
not
want to file a
here. I'm
motion to
here
modify
to cease
support,
and
you
exist.
should
All
file such a
Title
motion.
4D. Sir, do you have a contract in dispute with me? I'm asking the court, Ms. Zorn, to place end of court all evidence she has party on my contract. If not, I motion to dismiss with prejudice failure to state a cause of action. This goes against my Constitution, sir. Yeah, I understand Michigan law, but it must be in compliance with the Constitution. This has violated me as a man numerous times, and now I can't even make my bill. I'm asking you to give me 50-50 split of my kids. I made them in private. I will raise them in private. There is no need in dispute, nor has there ever been. You know what, sir, underneath Article 1, Section 13, Paragraph 5, I want to face my accuser. If we could please swear Ms. Zorn in so I could face my accuser here today, sir, I would appreciate it.
A special thank you goes out to Enemy of the State TV for sharing this video with me, because without them I probably wouldn't have come across it. And if you want to watch the entire clip completely uninterrupted and see everything exactly as it originally happened, there will be a link down in the description so you can check it out for yourself. But with that said, we're now moving on to our final video for today, and this one isn't exactly a follow-up to a previous sovereign citizen I've covered on the channel so much as it is a continuation of the same situation. The sovereign citizen featured in this clip was previously found responsible for a driving infraction during an earlier proceeding, but since he wasn't very happy with the outcome he received during that informal hearing, he decided to take things a step further by paying the required bond in order to challenge the decision. Which means what we're about to watch now is the formal hearing, where he tries once again to argue his case and push back against the ruling that was already made.
All right, so Mr. Smith, perhaps you should consult a constitutional lawyer. This matter is guided by state law. The court has made a decision.
Sir,
No change of circumstances that would warrant a change of custody parenting time. The court will not argue over you, Mr. Smith. So that will conclude, sir. You can zoom out.
Predetermination of this case.
An order will be entered. All right, Mr. Smith, consult an attorney.
Predetermination of this case, sir.
Oh, I get it now. You were traveling, right? That must be because you had your gear shifter and your trusty road canoe set to T instead of D, which obviously changes everything and magically transforms driving into something completely different. I guess in that version of reality, the rules of the road just don't apply the same way, because once you flip that imaginary switch from drive to travel, the laws somehow stop recognizing your vehicle as a car and start treating it like a completely different mode of transportation. It's a creative explanation, I'll give you that, but unfortunately for arguments like this, the courts and traffic laws tend to see things a lot more simply. If you're operating a motor vehicle on public roads, it doesn't really matter what label you decide to give it or what letter you think should be on the shifter, because from a legal standpoint, it's still considered driving.
How to initiate traffic stops and what to look for.
Okay. Were you on duty on May 24th, 2024 at approximately 9 p.m.?
I was.
What was the weather like at that time?
Weather that day was clear, and it was still light outside.
The road conditions?
Dry.
Okay. And you were on patrol at that time?
I was.
You were in a marked patrol car?
I was.
Where were you on patrol?
I was patrolling the downtown area near 11 Mile in Washington.
That's in the city of Royal Oak?
It is.
What happened at that time at those crossroads?
I was stopped at the 11 Mile and Washington light facing westbound. I had a green arrow and a vehicle proceeded eastbound on 11 Mile through a light, which gained my attention. That light was red for them, which drew my attention to that vehicle.
Okay, what type of vehicle was that?
I believe it was a black 2024 Ford Edge.
Is your vehicle equipped with a dash cam?
It is.
Judge, at this time, I'd like to play that video from Officer Moran's dash cam.
Okay.
Can the court see that?
I can.
Officer Moran, you can see that video that I pulled
can.
up?
Yep.
Okay. Just playing that video now, Judge.
Okay.
Edward John Lincoln, 65011, JL 65011. Yes.
Judge, I'm just gonna stop that video here.
Okay.
If defense would like to play the rest of the video subsequently, we can. I just wanted the court and Officer Moran to see the stop.
All right.
Is that the video taken from your patrol car?
That is the vehicle for my patrol vehicle.
Does that fairly and accurately portray the events of the incident that led to the defendant being issued a civil infraction on that date and time?
It does.
Your Honor, I'd ask that that video be admitted into evidence.
All right. So admitted.
Officer, so what do you see on that video?
What I see, like I spoke to earlier, I was stopped at the 11 Mile at Washington light facing westbound. I got the green arrow to turn southbound on Washington when a vehicle proceeded eastbound through, obviously, the red light.
And then you pulled that vehicle over?
Yes, I immediately initiated a traffic stop.
And that was on 11 Mile in the city of Royal Oak?
It was, yep.
When you approached that vehicle, did you observe the driver of that vehicle?
I did.
Do you recognize the driver of that vehicle on this Zoom today?
I do.
What's your objection?
Because I was traveling. I wasn't driving.
Oh, I get it. You were traveling because you had your gear shifter and your road canoe set to T and not D.
Okay, overruled. Go ahead. You can answer the question, Officer Moran.
Yes, I do see the defendant in the court today.
Your Honor, let the record reflect that Officer Moran has identified the defendant, Anthony Mathis.
The record will so reflect.
When you pulled the defendant over, did you have a conversation with him?
I did.
And in that conversation, did he admit to you that he had driven through the red light?
He did.
And ultimately, you issued him a ticket?
I did.
What was that ticket for that you had issued him?
I actually issued him an impeding traffic ticket.
Okay. But that's not what he actually did, correct?
No, that's not.
Why did you issue him an impeding traffic ticket?
Mr. Mathis at the time had a good driving record. He knew what he did. He told me he admitted to it, and he had a good attitude on the road. So I chose to go an impeding traffic ticket.
I object.
What's your objection?
I never admitted to anything. Do you guys have that on the record? Did you guys pull that up that I admitted to something?
You'll have a chance to.
That's false.
Mr. Mathis, you'll have a chance. Your objection's overruled. This is his testimony from his memory. You'll have a chance to testify yourself and add any additional evidence here. So at this point, that is not a proper objection. It's overruled. Anything else to add there to that?
What, just very briefly, Judge, what infraction did you actually observe?
I could have wrote him two infractions, either disobey traffic control device or disobey traffic signal.
And that's what he actually did, correct?
Correct.
Judge, I have nothing further at this time.
Now, Mr. Mathis, it's your opportunity to ask Officer Moran any questions that you feel are necessary. Now, I just want to instruct you. You'll have a chance to testify if you choose to in a moment. Right now, anything that you say should be in the form of a question directed at the officer. If you're going to start testifying, I'm going to have to interrupt you and redirect you. You'll have that chance in a moment. It's just to ask questions. So go ahead with any questions you have.
All right. Well, for the record, is there any injured party? Do we have a sworn affidavit or complaint from an injured party?
No, there's no injured party.
Okay, so we don't have any injured party. So Judge, you've been sworn in to uphold the Constitution, correct?
I'm not on the stand. I'm not answering any questions like that, Mr. Mathis, excuse me.
So what type of court is this? Is this Admiralty Maritime Law?
Mr. Mathis, right now is your opportunity to ask Officer Moran any questions that you want to. If you're going to make some legal objections or something along those lines, you can do that in your closing. But right now, this moment in time is for you to ask Officer Moran any questions.
Okay, well, for the record, we don't have any injured parties, correct?
Judge, that's been asked and answered.
Sustained. He already answered that question.
Right, correct. I just wanted to make sure that we got that on the record. So if there's no injured party here, then...
Because you broke the law and ran a red light, plain and simple, and it's not even a situation where there's any real confusion about what happened, since the officer saw it happen with his own 2 eyes while he was right there on the scene. And to make matters even clearer, it was also captured perfectly on his dash cam for everyone to see. That means there's both eyewitness testimony and video evidence showing exactly what took place. So, this really isn't a matter of interpretation or debate about whether it happened or not. At this point, all the arguments and technical wording in the world aren't going to change the basic facts of the situation. And what it really comes down to is accepting that the violation occurred and taking responsibility for your actions. Because that's ultimately the reason you're here dealing with this in the first place.
It should have been no type of charge of anything.
Hang on, Mr. Mathis. When there's just like when you made an objection, we all waited for the court to make a ruling. That's what you need to do. So Mr. Klusny just made an objection that your question was actually more of a legal argument. I think that's what your objection was, Mr. Klusny, correct?
Yes, Judge, I don't believe there was a question directed to the officer.
So I'm sustaining that objection. And again, you can make those legal arguments or whatever the case is that you want to make at the end. Right now, it's just questions or not to Officer Moran. Anything else?
No, that's the only question that I have. If there's no injured party, you said no one was injured.
All right. So, Mr. Klusny, would you like to call any additional witnesses? Or I should ask you first, any redirect of Officer Moran?
Not at this time, Judge.
All right. Then any additional witnesses, Mr. Klusny?
No, Your Honor.
Mr. Mathis, will you be testifying or do you have any witnesses that you'd like to call on your behalf?
No.
So, let me get this straight. You don't have any witnesses to support your side of the story, and you're not even planning to contest the officer's sworn statement about what happened. That basically means the only testimony on the record is the officer's account, which was given under oath. And from what it sounds like, you're not presenting anything that actually challenges it. At that point, it almost feels like the strategy is to just hope the judge somehow forgets everything that was just said during the testimony and the case simply disappears on its own. Obviously, that's not really how court works, which makes the whole situation pretty confusing from the outside looking in. Maybe someone out there can explain the logic behind that approach. Because right now, it's hard to see what the actual defense is supposed to be here.
Judge, based on the testimony of Officer Moran and the video, it's clear by a preponderance of evidence that the defendant committed the offense of disobeying a traffic signal. The authority for the stop comes from MCL 257.611. Or 257.612. I believe that's for the traffic control device. The video in this case could not be more clear, Judge. You see Officer Moran is in the left turn lane. He gets a green arrow, and the defendant in his vehicle has a red light, drives right through the red light. If Officer Moran didn't stop, he would have hit the defendant's vehicle because he went right through the red light. It's rare that we have a video that is as clear as this, Judge. And And the officer tried to give him a break by writing him for an impeding instead of what he actually did, which was disobeying a traffic signal. And I believe it's clear, based on the testimony in the video, that the defendant is responsible for that traffic offense of disobeying a traffic signal.
Repeat your change.
Yeah. Thank you.
You got the light?
Mr. Mathis, your closing argument?
Well, what I would like to say on the record is no one was injured. There's no injured parties. If you guys can't bring forth any injured party, then why are we still here? I need this to be dismissed, and the funds that was issued on the bond account needs to be reimbursed to me. Period. You guys don't have any injured party here. Based on the Constitution, the Sixth Amendment, if you guys can't bring forth the accuser, then this needs...
Well, here's the thing. The officer is literally sitting there with you on the Zoom call and just gave testimony right in front of you, but true to form, you're somehow misunderstanding and completely misapplying a right that's actually only granted to defendants in a criminal trial. You're taking that specific protection and trying to twist it to apply to yourself in a civil trial, which, let's be honest, makes about as much sense as the last constipation genius argument we saw. Civil cases, like the one you're defending yourself in, operate under a totally different set of rules, and no amount of creative interpretation is going to change that. The right to confront your accuser doesn't magically expand to cover civil matters like traffic violations or child support disputes. So, while it's impressive in a bizarre sort of way how confident you are in your reasoning, the reality is that the court sees it for exactly what it is, a fundamental misunderstanding of how the legal system actually works.
Not at the moment.
All right. Was there a bond posted? I'm not quite sure what he's talking
Absolutely.
about.
Judge, it looks like there was a $175 bond posted. Judge, I apologize. I actually, the file is here. I'm going to send the file into court.
Mr. Klusny, the amendment was to disobey a traffic signal, which is a... okay.
I apologize, Judge. The file coming into you.
That's all right. The amendment that the people made here was to disobey a traffic signal. Is that correct?
That's correct, Your Honor.
All right. The court's heard the testimony, the arguments of the parties, reviewed the video that was introduced as evidence. The video shows clearly the vehicle driven by Mr. Mathis to go through a red light, the traffic signal at 11 in Washington. The standard here at issue is preponderance. The video showed beyond any doubt, really, that that's what occurred. Also, there's testimony from Officer Moran that that Mr. Mathis did actually admit on the roadside that he had done what was alleged to have occurred here today. That testimony was uncontroverted by any other evidence that was introduced. With that, the court does find Mr. Mathis to be responsible for the amended charge of disobey a traffic signal. That's a $150 fine. Mr. Mathis has posted a $175 bond, so the court will apply the bond to the fine of $150. There's a $25 refund coming to Mr. Mathis.
All right, so that wraps up today's video. And to quickly summarize everything we just watched, we basically had 3 courtroom characters doing what they do best, losing spectacularly, while somehow managing to make the process even more absurd than it already was. From the male, Karen, threatening a judge, to the sovereign citizens refusing to pay child support or challenge driving infractions properly, each case was a masterclass in misunderstanding the law and overestimating their own legal genius. If you enjoyed watching these train wrecks unfold, go ahead and hit that like button. And if it wasn't your cup of tea, feel free to hit dislike. But either way, don't forget to leave a comment down below with your thoughts, reactions, or favorite moments from the chaos. And make sure to subscribe with notifications turned on so you never miss any of my content. Because there's always another wild courtroom story just around the corner.